At the end of our last section, we talked about the fact that at the end of a trial, at the end of a plea negotiation, there's going to be a sentence. The sentence is critical because it's the sentence that determines what punishment a person will actually get. Very, very importantly, and we'll underscore this a couple of different times, it's important to remember a sentence is not only to prison. In fact, more often than not, criminal sentences are to punishments within the community, like probation or probation on house arrest or some combination of that. And we'll come back to talk about that in a little bit. But it is important to keep in mind that when I say sentencing, it doesn't equal prison. Sentencing is sometimes about prison, but not always. So back to our main point. The sentencing determines the punishment. What determines the sentence? The sentences are based on statutes or laws. Remember, when we defined crime at the beginning of the semester, we said that one of the definitions of a crime is it has to have an attached punishment. Well, where does that punishment come from? It comes above all from a statute. Now, the law or the statute can be broader or narrower in how much discretion it allows the judge. So in some cases, the sentences do allow for judges to have a lot of choice in adapting or modifying the sentence, making it longer or shorter or harsher, or adding on constraints and so on. But in other cases, judges really have very little discretion. And as you'll see as we talk about some of the politics of sentencing and some of the politics of the criminal justice system, this is a huge question going forward, because what sentences should be and who gets to define them tends to be among the biggest questions in criminal justice reform today. We see this emphasis on politics in our discussion of punishment coming together in the very insightful point that punishments reflect the dominant values of a particular time and place in history. So in the United States, we haven't always thought of punishment in the same ways. Neither have other countries. And that starts with the idea that in a democracy where sentences are defined in law, sentences, the relative length of the sentences, the kind of punishments, the conditions of punishment are a choice of what the public wants and how they express that through their representatives. So we see in the early part of the United States history in the early 1900s, what we now think of as the modern prison was actually developed in the United States. It's where we get our name penitentiary from. And the idea over there was that people should go to prison in order to change, in order to be rehabilitated through penitence. This was a profoundly religious idea. And the very term penitentiary comes from this idea that we should go to prison to reflect on our crimes, which reflect moral wrongs, in other words, sins, and correct ourselves. Now, in practice, the penitentiaries were pretty awful places that were more like torture machines in terms of mental torture than they were places of reformation. And that's one of the reasons they changed. But there were many other moments of reform. For example, in the late 1800s and the early 1900s, we saw the rise of ideas of juvenile justice, as well as emphases on individual reform and sentencing tailored to individual needs, depending on your circumstances and your crime. One of the heydays of reform and rehabilitation in the United States was in the 1950s and 60s, when you got the rise of a very strong emphasis on rehabilitation, and that's also where we get the term corrections as a synonym for departments and projects of punishment. So instead of saying that this state or this government agency was a department of prisons, it became a department of corrections, the idea that we want to rehabilitate people by correcting them. In contrast to that, in the 1980s and 1990s, we saw a tremendous emphasis on retribution. We wanted to be as harsh and as tough on crime and as humanly possible. Politicians promised to put people in prison for as long as possible and throw away the key. And guess what? They tried to keep to their promises and make punishment harsh, long, and in some cases permanent. And so the 1980s and 1990s saw emphases on retribution, incapacitation, or in practice warehousing, and deterrence. There was very little emphasis on rehabilitation. In fact, there was almost no emphasis on rehabilitation. Where are we at today? The picture is pretty complicated. Rehabilitation has definitely made some sort of comeback, but retribution has not gone away. We still have some discussion of incapacitation and deterrence. Arguably, one of the reasons our policies are very mixed up in the current situation is that at a public level, we have a tremendous lack of clarity in our political debate. And going with that, we have a tremendous lack of resources to match our best intentions. So to the extent we say we are committed to rehabilitation, we are committed to second chances, we haven't necessarily reinvested in the educational resources or the physical infrastructure of prisons or the personnel and some of the other things that would allow us to be able to make rehabilitation more of a practical reality in our sentencing structures and in our sentencing practices in prisons, on parole, in probation. So one of the things I hope you've seen now is that there are a lot of influences on sentencing. We've already inferred the most important one of all, which is the law. The law stipulates what the sentencing requirements are, if any, and what options the judge has, if any. Judges might be called on through the law to address issues like the severity of the crime. There's a difference between killing somebody with premeditation and by accident, something we've talked about before. That makes a difference in severity. Has a person got a prior offense? Typically, prior offenses may not be brought up in the course of a trial, but they certainly can be brought up in the course of sentencing. Are there mitigating or aggravating circumstances that the judge should consider? And by the way, when we talk about death penalties and jury trials, juries very much have to consider aggravating and mitigating circumstances. And aggravating circumstances is something that would have the judge or jury think the crime is actually worse than it might initially seem. So, for example, if you had a murder that was preceded by torture, that would be an aggravating circumstance. In contrast, sometimes there are facts and information which may make us see the crime or the criminal in less harsh light. So, for example, if a person who murdered somebody following a long history of that person being abusive towards them, that might be a mitigating circumstance. Or if they had grown up in an environment that hadn't taught them about the correct way to deal with conflict and the fact that law enforcement might be a source of help rather than a source of hurt, that could all make a difference. There are lots of other people, though, aside from judges and juries, that make a difference in terms of what the sentence is going to be. Perhaps the most understated one of these is the prosecutor. He or she, as we've talked about before, in many ways has a huge role, maybe the largest role of all, in determining what the sentence is likely to be, insofar as they identify what a person is going to be charged with. And the charge almost always determines at least the parameters for the sentence, and when we talk about minimum mandatory sentences, often talks about the sentence itself. And we'll come back to minimum mandatory sentences in just a moment. Very often, when the judge considers what a sentence is going to be, he or she is going to look at a report called a pre-sentence report written by an officer of the court. It's often the probation officer, but not always, that puts together a whole lot of important materials that would help the judge make his or her decision. What does the law say? What does the prosecutor want? Is there victim testimony? Is there any sort of evidence of mitigation that needs to be considered? Is there any kind of aggravating information that needs to be considered? All of those things matter a lot. Finally, the judge will make his or her decision unless it's a death penalty case in which the jury decides on the sentence. Broadly speaking, we have two basic sentencing structures or means of sentencing. The one is called indeterminate sentences and the one is called determinate sentences. These are broad categories. Essentially, an indeterminate sentence is the idea that a judge would set a range of what a sentence would be, but in practice, a parole board would decide whether a person is going to be released at the early part of their sentence or the later part of their sentences. Indeterminate sentences have been profoundly diminished and decreased in number and in practice in the US for two reasons. First, many states actually just got rid of indeterminate sentences. Secondly, most jurisdictions have either got rid of or cut back on parole so that it is simply impossible in many situations to get parole. So let's focus on determinate sentences because this is where most sentencing happens in the United States. This is when a judge would sentence somebody to a precise and exact sentence. Somebody is sentenced to 16 months in prison, or 6 months in jail, or 3 consecutive 25-year sentences in prison. Those would be the examples of determinate sentencing. Now, there is some small possibility for decreasing those sentences, most often through something called a good time decrease, where a person is able to get slightly less of a sentence by behaving well in prison. However, that is sometimes offset or limited by truth in sentencing limits. These are rules that originated in the federal government but can be found at a state level and at the federal level that say a person needs to serve a certain percentage of their sentence before they can be released, even if they have exemplary behavior or even if there are other factors that might allow them to be released earlier. I mentioned a little bit ago the idea of a mandatory sentence or a minimum mandatory sentence. A mandatory sentence or a minimum mandatory sentence is an example of a determinate sentence. It's a type of determinate sentence. A mandatory sentence is a sentence that says a certain penalty must be imposed, and a minimum mandatory sentence says the minimum sentence that needs to be fulfilled before a person can be released is X or Y. And most of us have probably heard of 3 strikes sentences, and that would be an example of a minimum mandatory sentence. In general, the idea behind 3 strike sentencing is that if people commit 3 crimes of a certain type, they may face the possibility of various increases in their sentencing. In some cases, the second strike might be doubling the sentence, or the third strike might be the possibility of an extra 25 years or 25 years to life. California's 3 strikes laws became particularly noticeable on the public landscape because they were the broadest. We mentioned earlier on when we were talking about the Supreme Court and the Eighth Amendment that California actually allowed people to be sentenced to life in prison through the 3 strikes legislation for things like stealing a slice of pizza, stealing a video, stealing vitamin pills. And that was actually held up as constitutional by the United States Supreme Court. Those kind of very harsh rulings were very expensive as well as very harsh, partly because of expense, partly because of overcrowding, partly because of the beginnings of some public rethinking around the 3 strikes laws, as well as other factors. In 2012, California's 3 strikes laws were reformed. They weren't taken away, but they were reformed through Proposition 36 in California, which has somewhat limited the ability of prosecutors to call for 3 strikes laws and judges to implement them. So they're still there, but they're not as bad as they were. Just as three strikes laws are very controversial, so is the death penalty. It's probably one of the most controversial issues in the United States, both within the United States and how the United States is understood by the rest of the world, which for the most part has rejected the death penalty. Most democracies, certainly, and even many non-democracies around the world, rich and poor, developing and developed, don't have the death penalty, but we do at the federal level and in many states. The death penalty attracts a disproportionate amount of attention for all sorts of reasons, most of which we don't have chance to go into in this discussion. However, we can say a few important things about the death penalty. The first is that since the 1990s, and more particularly since the 2000s, we see an increasing paradox in the death penalty in that there are more and more people on death row, but there are a decreased number of executions. In large part, that has occurred because both the public and the judiciary have come to realize that there are many wrongful convictions that result in the death penalty. And that has led to situations like a conservative Republican governor of Illinois putting a moratorium on the death penalty after he discovered that 13 of the 25 people who were awaiting execution should actually not have been on death row. By the way, this was not a mistake that was uncovered by the criminal justice system checking itself. This was a mistake that was uncovered by people outside the criminal justice system. Journalists and journalism students, when we're looking at the Illinois example, as well as lawyers in situations like the Innocence Project in various parts of the country. The reality is we actually have very few death penalty sentences as a percentage of the total number of sentences in the United States, but it has an enormous influence on our system. For example, many of the rulings that the Supreme Court has developed modifying what law enforcement can do and what prosecutors can do and what defense lawyers can do have come out of death penalty cases being litigated. Now, there was a brief period of time between 1972 and 1976 where the death penalty was ruled entirely unconstitutional by the Supreme Court. But in making that ruling in a case called Furman in 1972, when the Supreme Court ruled that the death penalty constituted cruel and unusual punishment, the Supreme Court was only identifying it as cruel and unusual punishment as it was then administered. And the idea was, if legislatures at both the federal and state level could improve the way they had set up the death penalty could again be considered constitutional. And that happened in the Gregg case in 1976, when the Supreme Court accepted some reforms in legislation that Georgia had brought in. Among those reforms were the idea that death penalty trials needed to happen in two parts. These were called bifurcated trials, where juries first had to listen to evidence regarding whether the defendant was guilty or not guilty, and then, having decided whether the person was guilty or not guilty, if they were guilty, decide whether they should get the death penalty or life in prison without the possibility of parole. Since Gregg, implementation of the death penalty has continued, but controversies have not gone away, and in fact, if anything, they have increased over the last few years. In part, that's because, as Justice Thurgood Marshall said in 1986, execution is irremediable, and therefore death is different. We can't treat death in the same way because we can't undo mistakes we make in the death penalty. One of the reasons the death penalty has remained such a prominent issue is because of the issue of race. You might think at first glance that that's because the biggest reason, at least statistically speaking, a person is likely to be charged with a capital crime is because they're black. But actually, when researchers did a whole lot of studies to have a look at how race affects the death penalty, they found something much more subtle and much more interesting. It turns out in a whole lot of studies that the most important racial effect on the death penalty was the race of the victim of the crime of murder. So where prosecutors were dealing with a dead white person, they were much more likely to charge the perpetrator or the accused person with a capital offense than when they were dealing with the death of a black person. Arguably, this kind of example is a tremendously subtle way of conveying the differential way we in our society regard black versus white people, perhaps especially in the criminal justice system, and how in different ways we impute criminality to black people in the absence of any other information that might make us give pause or rethinking to some assumptions we've made. And therefore, and we'll pick this up right at the end of the course, we might want to look at some of the unconscious ways we think about race in our society and how that affects the death penalty, not just conscious intention, which is what the Supreme Court has tended to focus on. One could talk for hours about the many kinds of challenges that have occurred to the death penalty, some successful and some not. But they are all important because they all have implications beyond the death penalty itself. So in a final example from the Supreme Court, in 2003, in a case called Wiggins versus Smith, the Supreme Court said that if a lawyer is so bad that it would allow somebody to not actually get what amounts to a true defense, they have not had their Sixth Amendment guarantees to counsel, and that arose in a death penalty case. One final note that I want to make before we talk about some closing comments about changes in sentencing is that arguably many judges, as well as some policymakers and politicians, are quite acutely aware of what an outlier the US is internationally, at least in this regard. And there are some discussions in some quarters that look at different ways of looking at the death penalty, comparing the United States to other countries. There's also the question of embarrassment for the United States in the public and diplomatic realm, which is more about politics and less about law. If we take a little bit of a big picture view of sentencing, we go back to some of what we said in the introduction, which is that sentencing is at a point of change. In some senses, sentencing is always going to change because sentencing is a product of representatives in a democracy and judges, and there's flexibility, and there's human rethinking, and there's political activism. But in the situation we face in the contemporary criminal justice system, we find particular flux around sentencing. And that is because sentencing is one of the potential big fixes to the problems of mass incarceration and over-criminalization and over-incarceration that we find in the United States. In practice, states have been much more effective at changing their sentences than has the federal government. In large part, that's because states do a better job of achieving bipartisanship between Republicans and Democrats, where they can find common cause. In contrast, in Congress, both the House and the Senate found it much harder to agree across party lines in terms of actual voting. The funny thing is, if you speak to individual members of Congress, individual senators, they often will agree on the principles across party lines. But when you actually try and get them to pass legislation, that's something much harder. But there are also changes from other quarters. So there are minimal changes from Congress. There are minimal changes from the Supreme Court. There are minimal changes from the executive branch of the federal government, and there are a lot of changes at the state level. Having said that, the sad reality from my perspective is that after seeing a slight decrease in the rate of incarceration for a few years, we're once again seeing the rate of incarceration pick up again. And that's despite some of the improvements like the decrease of the powder and crack cocaine sentencing distinction, and the fact that judges now have increased latitude to be flexible in terms of using federal sentencing guidelines. Most of the progress where it's happened has happened in the states, but there's not enough there, and there's certainly not enough at the federal level.